You from Perth, Western Australia, and it is a cool 43 degrees Celsius here. All of you who are jealously sitting in the northern hemisphere, think of us as we are melting here. It is my extreme honor to welcome you all to session 3 of this international conference on comparative law, hosted by Amity University Law School in collaboration with the School of Business and Law at Edith Cowan University. My name is Shannon Bosch, and I'm the Associate Professor in law at Edith Cowan University, and I'm the moderator for the session, which is just a fancy way to say that I am the official timekeeper. We have the pleasure of hearing from 4 very distinguished guests today. They've each been given a 20-minute slot in the program. I know that 3 of our presenters are in the session. Jane, can you just check whether our last presenter is present and maybe reach out to her in the meantime?
Not yet.
Okay. So what I'm going to do is, instead of introducing all 4 speakers at the beginning, I'm going to introduce each one briefly before they speak. And when their 20 minutes is up, I will sound a little chime alarm. And that will be the sound for the speaker to wrap up their presentation. So our first presenter today is Professor Mark Tushnet, and he has got his video on there so we can see who Mark is. He is the William Nelson Cromwell Professor of Law Emeritus at the Harvard Law School in the United States. Professor Tushnet graduated from Harvard College and Yale Law School and served as a law clerk to Justice Thurgood Marshall. Professor Tushnet specializes in constitutional law and theory, including comparative constitutional law. His research includes studies of constitutional review in the United States and around the world, and the creation of other institutions for protecting constitutional democracy. He has authored several books and articles on federalism, civil rights, and the Supreme Court. Mark, the floor is yours.
Thank you very much. I'm happy to be able to present this talk, which is about the concept of constituent power in constitutional law and theory. The idea of constituent power is increasingly important in constitutional theory, with several major works being published in the past few years, but it has also become controversial. And I'm going to address the controversy a bit because to explain why I think 2 things. First, that the idea is an important one that we need to retain, but second, that the controversy is understandable because the domain of the idea of constituent power has been overextended. Now, the basic idea of constituent power has its origins in works by Abbé Sieyès in the period of the French Revolution, and then revived or elaborated by Carl Schmitt with respect to the Weimar Constitution. And what provoked each of them to think about and come up with the idea of constituent power was the following problem. They, post French Revolution, post the adoption of the Weimar Constitution, they were dealing with constitutions that needed to be explained as grounded in law. The problem was that each system replaced another one. The French post-constitutional system replaced the monarchy. The Weimar Constitution replaced the, call it the empire. And each of those predecessor systems did have rules, or I'll call them rules, about how they could be amended or replaced. But the French post-revolutionary constitution wasn't adopted in the manner prescribed by the prior constitutional regime. And similarly, the Weimar Constitution was not adopted by the processes prescribed in the prior constitutional order. That mattered because whenever you have a sort of subsequent development that can be traced to some earlier lawful arrangement, then the legality of that lawful arrangement can carry through to the new thing. And then you can trace it, everything all the way back, or a long way back until maybe you stop caring about it. The problem was, again, that the French post-revolutionary constitution and the Weimar Constitution were revolutionary transformations that displaced existing regimes in a manner that wasn't provided for in the then existing constitution, but that needed to be understood as fully lawful. Now, I want to claim, and I'll be arguing that in fact is the proper domain of the idea of constituent power. It's a way of explaining the foundation of a constitutional order that does not rest upon the foundation of a fully lawful constitutional order that does not rest upon any prior processes that were themselves lawful. Okay, so that's the domain. The idea, though, has been extended, I think, improperly. So for many, in much of the discussion, the constituent power is what makes all constitutions the constitution for the people of the nation. Sort of, when you look at a nation's constitution, you know it's the nation's constitution because the people of the nation have somehow brought that constitution into existence. Now, the first implication of that way of thinking about it is that there is an entity called the people of the nation. And that leads some, including Schmitt, to assume that there's a unified people. Typically, in Schmitt's case, an ethno-nationalist unified people. In other instances, it's a culturally unified people. So you have this, there's the people of the nation who have created their constitution. When you have this idea of there being the people of the nation, political leaders then emerge to claim that they and only they speak for that unified people. So Carl Schmitt embodied that in his idea of acclamation. The leaders' actions are endorsed by the acclamation of the unified people. Now, the basic mistake here is that you can have nations that are not unified in the way that Schmitt and others assume. Most notably, I have three options here, and there are probably others. You can have a nation whose self-understanding is multicultural, such as Canada, or in a more modern terminology, plurinational, which is Bolivia, or unified around a constitutional project of national self-understanding, which is the way many people I think of the United States as founded as unified around the notion that we are a people created by our adherence to the Constitution. Jürgen Habermas has a similar idea in his idea of constitutional patriotism. Okay, so those are the mistakes that can be made. What's the proper way to understand the idea of constituent power? Well, first, it's needed to deal with two related problems. The first is one that I've already introduced in describing the idea's origins. The problem is establishing the legality of the revolutionary displacement of an existing constitution in a manner inconsistent with that constitution's rules for amendment or replacement. And that's occurred quite frequently. Now, it's possible to say, well, when that kind of thing happens, the new regime is, maybe you can call it de facto lawful, but not fully lawful. But that seems unsatisfactory. These regimes, when they persist, which is a point I'll come back to, seem no different from regimes in which constitutions have succeeded each other through amendment and replacement processes. The second problem is one, it's more theoretical, although it's one that I've thought a lot about because it arises in connection with concerns about amending the US Constitution. Many people, here's the problem, many people, but not enough to satisfy the Constitution's amendment rules, believe that a specific change is urgently needed, but can't get it done because of the amendment rule. Now, for reasons of time, I omit
Mark, I think you're muted now for some reason, Mark.
Okay, sorry. Let's see.
The last thing we heard was for reasons of time, and then we lost you.
Okay, that's fine. I didn't say much after that. In both of the cases, irregular forms of constitutional change can be used. So, for example, you can have a constituent assembly that just comes together pursuant to organization by political leaders outside the framework of the existing constitutions. The Constitution that happened in some ways in the United States at its founding. More recently, it happened in Venezuela. Second situation, the problem that can't be solved under the amendment rules, you could have an unauthorized referendum to deal with the problem. Maybe we should conceptualize de Gaulle's referendum in, I think it was 1962, as that kind of action. My example is the failed effort in Catalonia to have an unauthorized referendum on Catalonian separation from the nation of Spain. So you have these two problems. Irregular forms of constitutional change will be used, and the concept of constituent power explains why or how the ensuing changes have the same normative weight as constitutional provisions adopted according to the existing amendment rules. Okay, so constituent power is the way in which a people exercise their power or their right to govern themselves however they wish in the two cases I've described, the revolutionary transformation and the amendment rules blocking needed change. In all other cases, the existing constitution is the way in which the people have chosen to govern themselves. They say, in the formulation of the Irish Constitution, we have given this constitution to ourselves and we'll follow it to deal with the problems that we think are going to arise. And when they do that, including amending the Constitution in light of new circumstances, when they do that, again, you can trace the legality backwards through the existing processes. It's only in these revolutionary or irregular changes where you need something special. Okay, so and those two cases, the revolutionary transformation and the amendment blocking problem, we have reason to think that the existing procedures aren't allowing self-government. Okay, so then the next problem is to figure out when the people have made one of these irregular choices. One way to do it is the mistake I've already mentioned, trying to identify the people who have made the decision. And here the problem is figuring out whether the nation is, just to use my categories from before, ethno-nationalist or cultural, or committed to a constitutional project. In circumstances where political leaders divide over that very characterization. So in Hungary today, we have a political leader now in charge of the country who characterizes Hungary in ethno-nationalist terms, and an opposition that characterizes Hungary in basically a constitutional project term, a project of liberal democracy. And in those circumstances, how do you know who the people are? It's just a political fight. So one way, the second way, which I think is the correct one, is easy to state, which is you wait and see. So you have these political leaders contending over the characterization of the nation. They do something irregular because, again, they're not able to accomplish their goals through amending the Constitution or working within the existing framework. They try, as in Catalonia, an irregular framework. Sometimes, as in Catalonia, they'll fail immediately. Sometimes the changes will go into effect. The Weimar Constitution or the Russian Revolution. And what you need to do is to wait to see whether they stick. That is, whether they become accepted by the nation as fully lawful. Now, there are some details here that I'll just mention without working them out. First, for something to stick, the opposition has to damp down over some reasonable time period. Damping down can occur because the opposition comes to accept the transformation, which sort of seems to maybe be happening in Venezuela, or in the United States, the opposition just basically fled. The loyalists just abandoned the United States, and so the revolutionary project was to be carried out by people who were committed to it. I said so, and then how long do you have to wait? The Weimar Constitution is a good example. It is adopted right after World War I. It's under severe stress through the 1920s and then collapses in 1933. Was that long enough for the Weimar Constitution to stick, to become fully lawful? Now, one difficulty remains, and I'll wrap up with this, and it's a very serious difficulty. I want to make it clear. Opportunistic politicians do use the idea of the constituent power abusively. These politicians claim that they already speak for the nation's people. Juan Perón in Argentina. I am speaking for Argentina. Now, without there having been any test of whether his constitutional irregularities would stick. In a recent important article, Sergio Verdugo argues that this sort of abuse is so likely that we ought to get rid of the idea of constituent power entirely. I'm not sure that that's possible. The idea is out there. There's no enforcement mechanism to stop politicians who abuse the idea, except maybe the condemnation of the sort of narrow community of constitutional theorists who might say, you're not using it in the right way. And as I've argued, and this is where I'll conclude, we need the idea of constituent power or something just like it, though maybe with a different name, to deal with the problem of identifying the basis for claims that revolutionary constitutions are fully legal. I want to finish with one footnote that's probably been lurking in my discussion, and that is this. I said you use the idea of the constituent power to deal with irregular constitutional transformations, that is, transformations that don't occur according to the procedures set out in the existing constitutions. And I argued that you needed it because everything else you could trace backwards through, what you've done now. You had an amendment or a constitutional replacement. That amendment was based upon the rules for amending the Constitution, or the replacement was based on the rules for replacing the Constitution, the prior Constitution. And then you look at where that Constitution came from and so on all the way backward. At some point, you get to a place where there is no prior Constitution, or you get to a place where the only thing you can say is this was a moment of revolutionary transformation. And so, although I frame my discussion in terms of the need for the concept to deal with relatively recent kinds of things, it probably is needed to deal with the foundation in the sort of bowels of history, forgotten period when the Constitution in place got started. So again, I think the attention people have been paying to the idea of constituent power is proper, but its domain needs to be more carefully specified than has occurred in both political and some scholarly discussion. Thank you.
Thank you, Mark, and thank you for, I didn't even have to use my bell. How good of an academic are you that you can time it? Thank you for those very thought-provoking comments on constituent power. As someone who is a citizen of South Africa's Rainbow Nation, much of what you had to say resonated with me. So thank you very much. Our second presenter today is Professor Richard Albert, and he is the William Stamps Farish Professor in Law, Professor of Government, and Director of Constitutional Studies at the University of Texas in Austin. He is the global thought leader on democratic development and is the co-president of the International Society of Public Law and the founding director of the International Forum on the Future of Constitutionalism. Professor Albert holds law and political science degrees from Yale, Oxford, and Harvard universities, and formerly served as a law clerk to the Chief Justice of the Supreme Court of Canada. He has published over 25 books on constitutional democracy, including constitutional amendments, making, breaking, and changing constitutions. He is currently the only Jamaican serving on the Constitutional Reform Committee, advising the Jamaican government on writing and enacting a new constitution for the country. He is the co-president of the International Society of Public Law and an elected member of the International Academy of Comparative Law. Professor Albert has served on the executive committee of the American Society of Comparative Law and has been a member of the executive committee of the Association of American Law Schools. He is the founder and director of the nonprofit International Forum on the Future of Constitutionalism, whose mission is to marshal knowledge and experience to build a world of opportunity, liberty, and dignity for all. Mark, the floor, not Mark, Albert. Professor Albert, the floor is yours.
Professor Bosch, thank you so much for your generous introduction. Dr. Matthew, thank you for your kind invitation. Hello to everyone. It's a pleasure to be with you. It is now 10 p.m. here in Austin, Texas. I'll have 20 minutes with you. Before I begin, I just want to say what a wonderful lecture to kick off this session by Mark Tushnet. I was here listening intently, and I wish we could devote the entire session to his thoughts because they're very, very important. And so I'm glad you had the chance to be exposed to these ideas, as was I. Before I begin, the remarks I'll be making will be drawn from a paper called Multi-Textual Constitutions. I've put in the chat box a link to the paper that was just published in December if you'd like to read it. And I also publish a periodic newsletter called The Leaflet, which exposes readers to new books and new articles, new ideas and conferences in the area of constitutionalism. So if that interests you, I do that at no cost. And so please do join our community of subscribers if that's of interest to you at all. I'm going to share my screen for my remarks, if I may. I see that I'm entitled to do that, so I'm going to share. If I can just get some kind of signal from someone that you can see my screen, I'd be much obliged.
Yeah, we
Yes,
can, Richard.
it is visible.
Perfect.
Thank you so much. So I would like to speak with you about the subject of a recent publication of mine published just
Sorry, we
Richard,
just
you've
lost
been
you.
muted.
looks like I was muted, but I'm now unmuted. The subject of a paper that I just published in December with the Virginia Law Review called Multi-Textual Constitutions. I want to tell you about it. And so let me begin with the typical distinction that certainly is familiar to everyone in this room. It certainly is a distinction that I'm familiar with because I began my first day of law school as a law student with this distinction. And the distinction is that constitutions in the world come in two forms, either written or unwritten. I think this distinction is incorrect and misleading. That is to say, there is no constitution that is fully unwritten, nor is there any constitution that is fully written. All national constitutions are in some way written down on paper. Even the paradigmatically unwritten constitution of the United Kingdom is made up of texts. Think of the Magna Carta, for example, or the Parliament Act of 1911, or the Human Rights Act of 1998. These are documents. These are higher laws. I'll explain a bit more about the UK context. Even though these documents are repealable by Parliament, they're entrenched nonetheless, politically entrenched nonetheless. But the point is that unwritten constitutions don't really exist. We call the UK Constitution unwritten. It's written down in large part, although it is also made up of unwritten constitutional norms that we refer to as conventions, constitutional conventions, or the Constitution of Israel. People call that unwritten. It's not unwritten. It's made up of basic laws. Or the Constitution of New Zealand. People call that unwritten. It is not. Just as there is no such thing as an unwritten constitution, there's no such thing as a completely written constitution. Even the paradigmatically written Constitution of the United States is in large measure unwritten. It too consists of unwritten constitutional norms. This point was made time and time again in the last administration, under the last president, where people argued that he was violating not the written text of the Constitution, but the unwritten norms that undergird the Constitution. So all constitutions consist of unwritten norms. And so if it doesn't make sense to call a constitution either fully written, nor does it make sense to call a constitution completely unwritten, then is there a way to distinguish between or among the constitutions of the world? And I think yes. I think indeed it is possible to do so. But it has not to do with whether a constitution is unwritten or written. It has to do with the number of documents that comprise the constitution of a given jurisdiction. So I want to go over 5 questions with you, if I could. 5 questions in the time that I have. First, what is a multi-textual constitution? 2, how do we create a multi-textual constitution? 3, can a unitextual constitution ever become multi-textual? 4, What are the strengths and weaknesses of a multi-textual constitution? And finally, fifth, is the US Constitution unitextual or multi-textual? So I began with this false distinction between written and unwritten constitutions, and I told you that that distinction really does not stand up to scrutiny. The better distinction is between those constitutions that comprise one document of higher law and those that comprise more than one document of higher law. And the distinction here is between a unitextual constitution and a multi-textual constitution. So what is a multi-textual constitution? This is the first question I want to go over with you. In contrast to a unitextual constitution, a multi-textual constitution consists of at least two different documents recognized as comprising the Constitution. So this is a contrast between singularity and multiplicity. A unitextual constitution has one document of higher law. A multi-textual constitution has multiple documents of higher law. The second distinction worth drawing between unitextual and multi-textual constitutions is between synchronicity and asynchronicity. What does that mean? Well, it means that the unitextual constitution comes into being at one time and one time alone, whereas a multi-textual constitution comes into being at time one, but at time 2, 3, 4, 5, etc., there can be new constitutional documents that are enacted that come to comprise the thing that we point to as the constitution of that jurisdiction. That's the asynchronicity. Third point of distinction between a unitextual and a multi-textual constitution has to do with supremacy. In the unitextual jurisdiction, that lone constitutional document exercises exclusive supremacy in the jurisdiction, whereas in a multi-textual constitutional order, the multiple documents that comprise the constitutions share supremacy under law. So supremacy is shared between or among the multiple documents that together comprise the thing we call the Constitution. Second question, how do we design a multi-textual constitution? Here there are two options. You can have a permanent design or a temporary design. A permanent design or a temporary design. For example, the Constitution of Italy has a founding document, but it authorizes the creation of other documents of constitutional significance that will share supremacy with the founding document. And so in the text of the Constitution itself, there's authorization given to enact new documents that will not be inferior to the founding document, but will sit alongside a plane of equal constitutional significance. So the Italian case is just one of many examples. Another example is the Constitution of Lithuania, where the founding document itself enumerates other documents that have constitutional status that are to be treated as constitutional equals to the founding document. So that's a different model of a permanent design of a multi-textual constitution. This is the model of enumeration, in contrast to the model of authorization that we see in Italy. You can also have a temporarily multi-textual constitution. Here I want to point to the case of Israel. Israel has a number of basic laws. These are higher laws in the jurisdiction. Now, the reason why the country has this body of higher laws that are disaggregated is because the Harari Resolution at the creation of the State of Israel issued the following plan for the country. We will begin by creating separate, self-standing higher laws called basic laws, and at some point we will group them together as one unitextual document. And so the idea is that the basic law structure would be temporary only until all of these higher laws, the basic laws, are brought together in one single solitary document. That has yet to happen, but it still remains the plan, I think, in Israel, that one day perhaps, a unitextual constitution will be designed. So let me now turn to the third question of 5 that I want to address with you today. Is it possible to go from a unitextual constitution to a multitextual constitution? In other words, the Constitution begins as a unitextual document. Is it possible to transform that unitextual constitution into a multitextual constitution? The answer is yes, and it's happened many times around the world. I'm going to give you just 3 ways in which that has happened. The first is by constitutional amendment. So it could be the case that in a unitextual jurisdiction, political actors amend the Constitution to authorize the creation of additional documents that are to sit at a plane of equal constitutional significance with the founding document. This was the case in Brazil. The Constitution went from unitextual to multitextual by constitutional amendment. A second way that this transition is possible is by political practice. It is possible that in a unitextual jurisdiction, political actors will come to treat a non-founding document as a constitutional significant document, and thereafter will understand the second document as being equal to the founding document. This does not happen by amendment in this case. It happens by political practice and political recognition by political actors, by the legal elite, a recognition that this document that was not enacted as a constitution should be treated as a constitutional document and sit on a plane of equal significance to the founding document. This happened in Denmark. And a third way that a unitextual constitution can be transformed into a multitextual constitution is by judicial interpretation. So for example, imagine there's a unitextual constitution, and over the course of judicial interpretation and the course of litigation, the ultimate arbiter of constitutional meaning, here let's say a constitutional court, interprets a non-constitutional document, so not the unitextual document, interprets another document as having constitutional status and requiring political actors to respect it as such, and in fact perhaps invalidating ordinary legislation for being inconsistent with this non-constitutional document. When the court does that, it identifies that non-constitutional document as indeed a constitutional document that should be equal in significance to the founding document. So it's very interesting. This has happened in many times around the world, and I'm thinking specifically of a couple of cases in France and in Canada. So where the Constitution has been transformed from unitextual to multitextual by judicial interpretation. Let me now turn to the fourth question that I want to deal with in our conversation. And the first half of this fourth question is, what are the strengths of a multitextual constitution? The second half will be, what are the weaknesses of a multitextual constitution? So let me identify some strengths. One is constitutional flexibility. So if you imagine a unitextual constitution, imagine that there's great fidelity among political actors and the people to the Constitution. They may not want to change the text of that Constitution for whatever reason. In the United States, we call this veneration. At least my colleague Sandy Levinson has excavated this term from James Madison in the way he thought of the Constitution. But there's a veneration of the Constitution, and that makes people less willing to tinker with the Constitution's text by amendment. And so one strength of a multitextual constitution is that it allows change to be made in the constitutional order without changing the founding constitutional document. How? By just creating a separate self-standing constitution. A second strength associated with multitextual constitutions is in the transitional phase from one kind of regime to another. So imagine a constitution which is unitextual within an order that is illiberal. Now imagine that political actors want to transition to a liberal constitutional democracy. Well, you can use the idea of a multi-textual constitution as a bridge from one regime type to the next by enacting a little or a small constitution that exists in a separate document alongside the old document to be ultimately replaced. This is what the Polish did on 3 occasions by enacting a little or small constitution as a bridge from one regime type to another. Evidence of a multi-textual constitutional tradition in Poland. And a third strength is related to the first, is that it avoids the problem of veneration. Where you have a constitution that exists across different sites of constitutional significance, a multi-textual constitution, veneration is less likely to occur. And we've seen this, in fact, in Austria. Austria's constitution is made up of dozens and dozens of documents. And precisely because it cannot be packaged in a small little book like the US Constitution, the people do not venerate their constitution in the same way that Americans venerate theirs. And for some people, that's a good thing. I see that I have about 3 minutes left, so I'm going to accelerate my remarks. I wanted to touch upon some weaknesses. I'm just going to list them, but I'm happy to talk with any of you by email or phone or Zoom in the future. First is there's a problem in multi-textual jurisdictions of constitutional identification. How do we know what the Constitution is? If it exists in these different documents of equal constitutional significance, how do we know whether this document or that document is a constitutional document or not? So that's a problem in some jurisdictions, including Canada. A second problem is a problem of elevation. This is associated with courts identifying this or that other constitutional document as part of the Constitution, where that document was first not enacted as a constitutional document. So imagine a jurisdiction where there's a unitextual constitution. A court could say, and indeed has said in many countries, this non-constitutional document you must treat as part of the Constitution, thereby elevating that document from ordinary to constitutional status. That, I think, causes a problem in many different ways that we can talk about another time if that interests you. And finally, third, what do you do when there's a conflict between 2 constitutional documents? This arises in multi-textual constitutional orders. Document 1 will say X, document 2 will say Y. Well, someone has to resolve the conflict, which could lead to the actual possibility that one of the 2 constitutional documents is unconstitutional. That creates instability in the regime. The last question I wanted to raise for you is about the US Constitution. Is it unitextual or multi-textual? Well, you know that the US Constitution begins with the words, "We the people," and it ends with the many signatures of those who were present at the Philadelphia State House in 1787 who wrote the Constitution. But then after these signatures, probably in your mind's eye, you can recognize that the next thing to come is a set of amendments, the first, second, third, all the way down to the 27th Amendment. What if I tell you that the US Constitution, as it was enacted, is located in the Museum of the National Archives, the Rotunda? This is one of the copies here. This is the original Constitution. And that the Bill of Rights is not, in fact, this singular document that also appears in the Rotunda of the National Archives Museum. This is the proposal of the Bill of Rights in the year 1791. This is the proposed document. The actual amendments actually appear as separate self-standing enactments. This is an amendment to the Constitution. That's an amendment to the Constitution. Those are amendments. So the amendments are not, in fact, appended to the end of the Constitution. They exist in separate sites of constitutional significance. So it means that, and I'm going to end in 30 seconds, it means that the 3 items according to which we distinguish a unitextual constitution from a multitextual constitution. The three items in relation to the US Constitution seem to suggest that the US Constitution is multitextual. It has multiple documents. Each of the amendments, along with the US Constitution, they were adopted asynchronously. And each of the documents, the founding and the amendments, they share a supremacy. So it could be that the US Constitution is multi-textual. So we've covered a lot of ground today. We've answered these questions. What's a multi-textual constitution? How do we create one? Can a unitextual constitution ever become multi-textual? Are there strengths and weaknesses? And is the US Constitution multi-textual or unitextual? I thank you so much for your patience, for your interest, for your invitation, Dr. Bosch and Dr. Matthew. Thank you so very much. I look forward to the rest of the sessions today. I think you're muted, Dr. Bosch, Professor Bosch.
Yeah, you did right. Thank you so much. That was such an engaging presentation on exploring multi and unitextual constitutions. I say that is something that I haven't really given much thought to, but you have a lovely way of unpacking the concepts in such a logical and methodical way. Where were you when I was studying constitutional law? It's really a pleasure to watch your presentation. Thank you so very much. Our next speaker is Mr. Siddharth Mahajan. He is a partner at Athena Legal in New Delhi. Welcome. He is an accomplished legal professional with over 20 years of post-qualification experience. He graduated from a BA/BL Honours with a gold medal from Nalsar University of Law in Hyderabad, and he advises clients globally and has worked with leading Indian and overseas law firms. His areas of expertise include intellectual property rights, commercial law, technology law, media and entertainment, and dispute resolution. He is a prolific author who has gained national and international recognition for his publications on a wide range of legal issues. Siddharth, the floor is yours. You have 20 minutes, and I will time you out to let you know that to wrap it up if you overstep the time. But we will look forward to hearing from you.
Thank you. Thanks a lot. So, good morning, good afternoon, good evening, everyone, wherever you are located. So, we've heard eminent academicians speaking on the various issues regarding constitutional law, but I will try to delve into the issues related to technology law and issues related to metaverse especially, and how various countries are trying to grapple with the regulatory issues concerning metaverse and Web 3.0 technologies, which are very common and are widely being adopted. So, can someone run the slide, please, or can I share my own?
Jane, is Siddharth able to share his screen?
No, can I share my own screen? Because
go for it. That's perfect. Lovely. Wonderful. Share your own screen.
Yeah, so I've stopped sharing. Sorry, I had to move away from my laptop. If you want, I can share it again. Okay.
Yes, please. Thank you. If you can. Yes. So let's start with the topic of what is metaverse. Now, metaverse is essentially a interconnected world which is equipped with augmented reality, virtual reality, and extended reality. So in order to access metaverse, we have to use various tools, and these tools help us to access metaverse. And inside metaverse, when we enter metaverse, we create our avatars, and avatars basically have the capacity to do various things. They can buy stuff, they can travel, they can do anything. So it is a virtual world. So what are the key elements of metaverse? So key elements of metaverse are essentially uh, it is a blockchain. It is a blockchain powered technology, because earlier also we had immersive technologies, but what sets metaverse apart is the power of blockchain. Then metaverse is capable of smart contracts where you input something and the output is fixed. uh, the currency which is used in metaverse is usually crypto tokens, which by which people trade and do various commerce. Metaverse is a lot of times governed by what is called as decentralized autonomous organizations. Now there are various legal issues with these organizations as well. Then uh, in order to establish ownership of something in metaverse, we have non-fungible tokens, which as commonly known as NFTs. They give you the rights and ownership to various aspects of metaverse. And lastly, to access metaverse, we need various types of AR and VR devices. So there are number of metaverse platforms now, and most common amongst them are Horizon World, which is owned by Meta. Then there is Decentraland, which is essentially where people can own and sell property. And Roblox is very common amongst youngsters and kids because it has a lot of games and a lot of virtual currency is used in this virtual world.
1 second, please.
Yeah.
The slides are not moving. Can I request the slides to be changed, please?
Can you move further? Next one. Next one. Next one. Next. So coming on to the issue of comparative law, which is the topic of today's conference. So I believe that something like metaverse, which transcends territoriality of various countries, the geographical boundaries and political boundaries do not make any difference, and a person computer systems are accessible anywhere. So I think it is very important that different countries, we do a study of laws, how are they being implemented and how are they being drafted in different countries. Can you move the slide, please? So comparative law essentially is the study where we study where we do analysis of different legal systems across jurisdictions. And as I said, metaverse transcends physical boundaries. So therefore, the traditional legal frameworks may not be as applicable and may not be as relevant. And through the study of comparative law, policymakers and academicians, they can probably come up with the issues which can tackle potential conflicts and harmonize the whole experience and protect consumer interest. So what are the kind of legal issues which we usually face in metaverse? Next slide, please. So essentially, there are virtual property rights because NFTs are bought and sold. There are issues with regard to that. There is a great issue of identity theft and misuse of each other's identity with issues like deep fake, which is very common now. Now there is whole lot of virtual economy, and there are issues with regard to taxation, that how that has to be taxed. Very important issue of data privacy and data security of individuals, because what we need to realize is that in metaverse a lot of personal data is collected of various individuals, so that needs to be protected. Then there are very common intellectual property rights issues where trademarks and copyrights of different entities are misused. Then there is an issue of virtual harassment and discrimination on metaverse. And recently in UK, we had a case where there was an allegation of a digital rape by a 16-year-old girl. However, it is yet to be seen that whether the existing laws in UK, whether they'll be able to take any action on this kind of issue or not. And then there is a very relevant challenge of jurisdiction, that when you are located in different countries, what laws will apply and how will you actually prosecute someone who's done something wrong. Next slide. So you can move next one. So, what are the various approaches to regulating metaverse? What we have seen is that different countries have taken different approaches, and we will do a brief analysis of different countries and what are the approaches which are being taken regarding various elements of metaverse. Next slide. Can you move the next slide? Yeah, so first we'll start with India. So Indian constitution essentially guarantees free speech and right to privacy, which is part of right to life. So there have been two very significant judgments in India. One with regard to your protection of online speech, which was Shreya Singhal versus Union of India, where the online speech was where the rights to freedom of speech online were restored, and Section 66A of the Information Technology Act was struck down. And second was Justice K.S. Puttaswamy versus Union of India, which laid essentially the foundation of the whole privacy and data protection regime in India. So this judgment gave the uh, put right to privacy as part of right to life, and this was another very significant judgment. Next one. So all the online interactions, including in metaverse, will in India right now are primarily governed by Information Technology Act, and there are various sections which cover various elements, like damage to computer source is Section 43. There are sections which deal with identity theft, cheating, violation of privacy, cyber terrorism, publishing obscene material, transmitting any obscene material, and basically and with regard to protection of children. So this is presently the act. However, this act is being overhauled now with the new Digital India Act, which is expected to be rolled out soon. Next. Besides the Information Technology Act, there is the Indian Penal Code 1860, which is the main criminal law, which is again being revamped now. So this also covers a lot of aspects of online behavior, which can be covered under this. Then there is Digital Data Protection Act, which started with the entire Justice Puttaswamy judgment. And this act has, as we all know, this has been passed and the rules are yet to be framed. So this act essentially gives a lot of rights to the uh, the person who owns the data, and he has the right to essentially know that how his data is being used, and he has the right to recover his data or to erase his data, and to ensure that his data is not used in a manner which he has not permitted. Next, please. So since so coming to other jurisdictions, in Australia there is again a Privacy Act, which is again extraterritorial, and anything which is connected to Australian citizen or has any Australian link, any business which has that has to follow this Australian Privacy Act of 1988. And the second important legislation is the Online Safety Act, which again is to ensure that uh, uh, there is no misuse of online resources, and all the entities which provide online services have to basically adhere to this Online Safety Act. Next slide, please. Uh, Globally, then European Union, as we all know, GDPR is one law which is being followed in most jurisdictions with regard to privacy. Then there is Digital Services Act, which aims to regulate online platform and services within EU. It imposes obligations on platforms to manage risks related to illegal and harmful content, and ensures online safety. Then there is e-privacy regulation, which is again like GDPR, but it is more focused on the online behavior. Next. United Kingdom again has Data Protection Act, which is very similar to GDPR. They have the Online Safety Act, which again aims to regulate online behavior of individuals. And then there is a very important age-appropriate design code, which is to ensure that the children below certain age are not given access to the harmful content. Next, please. So United States again has Communications Decency Act, which provides immunity to online platforms. Then state level, they have a lot of state level data privacy laws in various states. So there is no one law in United States. Different states have enacted different laws. And then there is the law to protect online privacy of children and children rights. Next slide, please. So, since cryptocurrency also forms a very important part of Web3 and metaverse, so in India, this has been defined as a virtual digital asset, and the government has put a different tax regime for this. So, as we will see that in different jurisdictions, this digital asset has been treated differently. India has taken a different view and not treated it as a normal property, but they've defined it as a virtual digital asset. Next. Now, Argentinian and Canadian governments have allowed use of cryptocurrency, but have not recognized it as legal tender. In United States, it is treated differently. Some regulators treat it as securities, some treat it as commodity, and and there is also a talk whether it can be treated as a currency. In European Union, there is they have set up a crypto regulator who aims to regulate all the cryptocurrencies and crypto exchanges. Then China has banned crypto enterprises and cryptocurrencies. Japan has taken a very progressive approach and it has regularized cryptocurrencies as legal property, and all the crypto exchanges have to be registered with the regulator. And Australia classifies cryptocurrencies as legal property, subjecting them to various taxes which are applicable to property. Now we'll go through some of interesting cases which have happened in various jurisdictions and how different courts have taken different views. So one of the earliest cases was Nike versus StockX, where Nike trademark was used as an NFT by StockX, and essentially the NFT could be exchanged for actual shoes. So Nike sued StockX for trademark infringement. Then Yuga Labs versus Rips. This was another very interesting case where Yuga Labs had a limited series NFT which was quite valuable, but the defendant here, he started making funny NFTs using the trademarks of Yuga Labs, and then Yuga Labs basically contended that their trademarks are being diluted and their value is being decreased. So they sued Rips, and in this they succeeded, and they were also granted damages to $1.57 million. Then Hermes versus Rothschild, where the NFT was created using Birkins and adding the prefix meta with the Birkins. So here again the Hermes, they sued the defendant and alleging trademark infringement, and they succeeded in that. Next, please. So there have been few copyright cases also with regard to metaverse and NFTs. One famous case is Rockefeller Records, where Jay-Z's debut album, a part of it was tried to be sold as an NFT, but again they could not succeed. Miramax versus Tarantino is another very famous case where the famous director Tarantino, he tried to make NFTs of the handwritten script of the movie. So here again the plaintiff succeeded, as it was held that the Tarantino did not have the rights to actually use the content on the NFTs. Next, please. Next slide. So another important issue which arises with regard to NFTs and cryptos is that whether it is treated as a property or not. So this is an interesting case from UK where the plaintiff brought proceedings against unknown defendants. So basically, the plaintiff created an account with a wallet provider called Ozone. So Ozone, she put some NFTs in Ozone which were stolen. Now, Ozone was not domiciled in UK. However, the court held that NFTs are very similar to actual property, and they passed an injunction order and also directed Ozone to disclose the names of the people, where to disclose the details of the wallets in which the stolen NFTs were put. So this is one judgment which actually said that NFTs could be treated as a property. Similarly, in Singapore court also, NFT was treated as a property, and injunction was granted against further transfer and use of NFTs by the defendants. And the court gave a very detailed order that NFTs are like any other collateral or any other property, and they cannot be treated any differently than any other actual collateral. Next, please. Now, in India, we've not had many cases with regard to NFTs or Web3 elements. However, one interesting case was digital collectibles versus Galactus. Now, here what happened was there was this NFT platform called Rario, which had exclusive license agreements with a lot of. Now there was defendant which ran a platform called Mobile Premier League. So they started making NFTs with the images of famous Indian cricketers who then sued Mobile Premier League. But the court held that as long as you are using the publicly available images of the cricketers, it does not amount to infringement, or it may lead to any connection with the plaintiff. So this is an important case with regard to personality rights and how uh, personality rights can be used with the NFTs. Then another famous case which was widely covered was filed by Anil Kapoor, who got an injunction against use of his voice, likeness, persona by third parties using deep fake technologies. And the courts have actually in these cases given a wide-ranging analysis of the personality rights regime in India. Now, based on the above, there are a lot of governance issues which arise in metaverse because metaverse, as we've seen, it transcends various jurisdictions, and at the end of the day, you don't know what law to implement and how to basically enforce the orders of various courts. So, few elements which can be done is that it is very important for any platform or a metaverse platform to have a robust data management policies, because a lot of personal data of people is being taken, and if that is misused, then it may lead to grave consequences. uh, Countries need to sit together and make laws and regulations which are common and which could be enforced, like it is being done in various crypto cases. Can you go back, please? Yeah, in various crypto elements where the governments have held that a global norm will be set up under the IMF, and GDPR is another example of this. Then it is very important that platforms also take some responsibility of enforcing the behavior, and individuals also address their rights and responsibilities on these platforms. Then, as we've discussed, international law enforcement cooperation is very important. Going forward, when a lot of things will be done by avatars of individuals, then one will have to really see that what are the rights and liabilities of these avatars, and in the AI dominated world, how much can you control these avatars. Then finally, the issue of security and safety of the users, and also of the platforms, which is very important. So robust cyber security policies need to be in place. And lastly, the governments need to have a lot of future thinking policies with regard to development of metaverse and web 3 elements. Now, it is very important that comparative law analysis is done, and laws in various jurisdictions are analyzed by the lawmakers and academicians to come up with practical solutions which can help regulate metaverse. Because see, at the end of the day, some kind of regulation will be required, and it will have to be harmonious across the world. Example could be the GDPR and the DSA, which are being followed and implemented across the world. A lot of inspiration is being taken by these laws in various countries. Uh, it is essential to harmonize legal frameworks across the world to regulate these things. And essentially, through the study of comparative amongst its users and upholds fundamental rights. Can you change the slide, please?
Thank you so much, Siddharth. That was such an interesting presentation on the metaverse. Your comparative research is going to be absolutely critical to finding common ground across the multiple jurisdictions that this metaverse straddles. And I imagine that just as one is developing regulations, so the metaverse is changing. So you're definitely not going to be out of a job anytime soon. Thank you very much for your fantastic presentation. Jane, can we just check that our next speaker is in fact with us?
She has not joined.
She's not
you
joined.
can take the question and answer if
Yeah,
Richard is
let's
there
do that.
and Mark is also there. If any questions, you can also ask
Perfect.
questions.
Okay. Lovely. So let's see. Mark, Richard, Siddharth, would you like to put your cameras on?
Yeah.
There we go. We've got Mark. Thank you. And Richard, Siddharth, don't go anywhere. Put your camera on and unmute yourself. And then if there are any questions, if you can just raise your hand from members of the audience, just raise your hand so we can create some sort of order queue. No questions. My goodness. I think we're all too worried about what the metaverse is going to mean for all of us. Mark, any concluding remarks from you?
I'm not sure that I do. Partly because it's quite late for me. It seemed to me when there was some resonance with between my comments and Richard's about multi-text. The one way of understanding my approach would be to say that you have to think of constituent power in quite specific circumstances, and the sort of sedimented way that some of Richard's multi-textual constitutions develop seems to me to have some similarities to the tracing back idea that I articulated. But I have to say, I have to think more about that. And midnight my time is not a good time for me to do that.
Perhaps there's a paper that you and Richard can co-author in that. Richard, any concluding remarks from you? Richard, have we lost you? If you're speaking, you're on mute. No, we seem to have lost Richard. And Siddharth, any concluding remarks from you before we round up our session?
Oh, can you hear me? I'm sorry,
Yes,
towards
I
the
can.
end of my speech, there was some issue at my end, so I couldn't hear the last part. So I had concluded. Yeah, it was a very interesting session. Mine was a little different than the great emphasis on the constitutional law and the issues. So I thought might as well talk about something which is very relevant today. So I think it was a great
Absolutely.
opportunity, and I really thank MIT University and all the panelists for having me here. Thank you.
Absolutely. And when I think about what you have had to, or what you've presented on, it's probably something that strikes fear into the heart of most of us who have qualified and done our degrees and all our studies prior to the invention of this metaverse. And so it's all foreign to us. And all of our concepts of property and contract are just completely up in the air when one thinks of something like the metaverse. And we are going to have to revisit all of our understandings to navigate our way. So thank you very much for really another thought-provoking presentation. Jane, if we still don't have our last presenter with us, I noticed she hasn't been with us for the whole day.
She has not joined. I believe there is some problem. We are not able to get in touch with her also.
Okay, not a problem. And Professor Banu had already pulled out.
Yes,
he has pulled out. He was not well.
Oh, that's sad to hear. Well, it's been such a delight to moderate the session, and my sincere thanks must go to our 3 distinguished speakers for graciously sharing their wisdom with us. Thank you to Amity for providing this platform for showcasing this really excellent research. Thank you for all our attendees. I see we're sitting at 45. It's such a lovely a room, such a full room. That's wonderful. I wish you all a really fantastic conference further, and I wish to close off before the reading of the citation in honor of our speakers with this quote from the late Nelson Mandela. Education is the most powerful weapon which you can use to change the world. And I would like to just thank Mark, Richard, and Siddharth for the world that they are changing through the education. So would you like to proceed now with the reading of the citation, Jane? Sorry, I think I might have gone out of order of your...
We'll be just sharing the citation. We'd like to present the first citation. The citation is presented to Professor Mark Tushnet in the keynote speaker session of the International Conference on Comparative Law on Friday, the 10th day of February 2024. Professor Tushnet, a legal scholar of comparative constitutional law, is an academician par excellence. A crusader for protecting institutions of constitutional democracy, Professor Tushnet has immensely contributed to this conference. We are extremely grateful to Professor Tushnet for sparing his precious time and delivering a thought-provoking address. We hereby recognize the contribution made by Professor Tushnet and express our deepest sense of gratitude to him. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia. Thank you so much, Professor Mark Tushnet, for being with us today. The next citation reads as follows. This citation is presented to Professor Richard Albert in the keynote speaker session of the International Conference on Comparative Law on Friday, the 10th day of February 2024. Professor Albert is a distinguished academician with several accolades to his credit for his exceptional contribution in the area of comparative law. Professor Albert, a supporter of constitutional reform, is an erudite personality with vast knowledge and experience and has carved a distinctive niche for himself in the area of comparative constitutional law. We are thankful to Professor Albert for his invaluable discourse and taking time to be a part of this conference. We hereby recognize the contribution made by Professor Albert and extend our heartfelt gratitude to him. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia. Thank you so much, Professor Richard. The next citation reads as follows. The citation is presented to Mr. Siddharth Mahajan in the keynote speaker session of the International Conference on Comparative Law on it's Saturday over here, the 10th day of February 2024. Mr. Mahajan, a legal professional specializing in intellectual property rights and technology laws, an illustrious personality with profuse knowledge and enthusiasm towards IP laws, has contributed immensely to the conference by his insightful and inspiring words. We extend our sincere thanks to Mr. Mahajan for sparing his valuable time and enlightening us with his words of wisdom. We hereby recognize the contribution made by Mr. Mahajan and extend our sincere thanks to him. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia. Thank you so much to all the speakers who have graced this occasion and being a panelist for our keynote session 3. Yeah, we have immensely gained knowledge from all your discourses and hope to have interactions with you in future also.
I also like to thank our session moderator, Shannon Bosch from Edith University. You have wonderfully managed the entire session. Thank you very much.
Thank you, everyone. It was such a pleasure. I believe there will now be the signing of the MOU.
Yes, but that's going to be in a physical format in the university campus over here. So
Perfect.
the
So
next
not in the metaverse.
yeah, not on the metaverse.
Not on the metaverse. Thank you very much, everyone. Enjoy the conference further. Mark, I hope you get some good sleep now.
Thank you very much.
Thank
Good night, good
Thank
day, good whatever. Thanks very much. Bye.
Bye-bye.
Thank you very much. IT support. Can we close the meeting and can we like reopen this meeting at 11:30 again? Because our last keynote session 4 is going to resume at 12 p.m.